Good morning. This is the Energy and Carbon Management Commission for the state of Colorado. It is Wednesday, December 10th at 9 a.m. This is our business agenda for the week. We start with a roll call.
Thank you, Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner Mesner.
Here.
Commissioner Oath.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
Good morning, everybody. Good to see folks. We have a busy agenda, so let's get into it. We start with commissioner comments. Does any commissioner have comments for the rest of us and/or our stakeholders? Seeing none, we move to consent agenda. Does anyone have questions on consent? Seeing none, do we have a motion to approve consent?
So moved.
Second.
Motion and a second. Any discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. All right, we've got a couple of update presentations. The first is a Form 27 processing update presentation by Audrey Blakeman, the ECMC Environmental Manager. Good morning.
Good morning. Bear with me 1 second while I get the screen shared. All right, is everybody seeing a presentation on the screen?
We are.
Perfect. Well, thank you so much for having me this morning. For those of you in the audience that may not know who I am, I'm Audrey Blakeman, the Environmental Manager here at ECMC. This morning, I'm joining the commission hearing to provide a brief update on how the environmental unit will be prioritizing and processing Form 27s related to facility decommissioning. So prior to that, since we may have people in the audience that aren't fully aware of what we do, I wanted to give just a brief overview of what the environmental unit's work looks like before we dive into the details of that. But the environmental unit, as seen on the map on your screen, we're divided by area, and our unit consists of a team of reclamation specialists. We have 3 teams of environmental specialists, and we have data management experts that work throughout the state. And these folks provide oversight during a number of events. So spills and release responses, we monitor remediation projects, respond to complaints, we process an enormous volume of environmental sampling data, we review waste management plans, we permit centralized exploration and production facilities, and we ensure that oil and gas, deep geothermal, or CO2 injection sites are restored to their pre-disturbance conditions after those activities cease. So, among those responsibilities, staff workloads are driven primarily by the forms that we receive. So these include the Form 19s, which are spill reports, and Form 27s, which are our remediation work plans. So today I'm going to focus on the environmental protection specialists in our group and some of the process improvements that we've implemented in their workflows. So our biggest workload driver is the remediation work plan, which is submitted as a Form 27 by operators. And then our staff reviews that to ensure compliance with our 900 series rules. So the challenge here with the Form 27 is the large variability in what the scope may be. So this includes everything from a simple project, such as decommissioning a small facility, all the way to very complex sites that involve thousands of laboratory samples that need to be processed and analyzed. So this variability means that the time that is required for review of a Form 27 may vary dramatically. So if it's a simple form, it can take around 20 minutes, but there are very, very complex forms that can take staff multiple days to complete. Volume is also a challenge. So yesterday alone, we received 187 Form 27s that had 401 attachments for review. So currently, our team is managing a significant backlog of Form 27s, and that's because our staff resources have been deployed to support multiple large-scale, high-priority projects that fall outside of what our normal day-to-day workflow is. So here is a slide that shows a table of our current backlog of forms. This is current as of Monday this week. So in this backlog, we have 4,621 Form 27s divided between our 3 environmental areas that our environmental protection specialists work in. So, as we look at this backlog and we look to prioritize and strategize where we dedicate our resources, we work together to determine what is and isn't working in our workflow. And we've put together a couple of different strategies to try to tackle this beast. The first thing that we did was we started trying to balance the work across the state. So that earlier map had names on it. That's typically our forms are assigned as they come in by area. So somebody may be assigned to a certain area and all the forms from that area will spill into their queue. But what we've done is we've started to distribute them differently. So some operators should expect to see staff reviews from people that they don't normally work with, since they're being assigned to staff that are in different areas of the state. And then we've also asked our internal technology team to develop a tool where we can just in bulk reassign forms across the state. So as someone gets a pile of forms, we can evenly spread those out so that they can get addressed. And then another change that we've implemented is we're having select members of our team perform QA/QC on recently submitted forms, and that helps to identify errors and trends that are happening prior to a cascade of the same issue across multiple forms. So operators can expect to see issues identified earlier and probably from reviewers outside of their assigned area where they would typically expect to see their forms go. Um, and then another process that we've evaluated is the status update of forms. And we've put together a tool for bulk processing, which has been highly successful. So in this case, all forms that have 0 attachments are considered for bulk processing. So if we receive a form that had documented impacts and they provide a status update that no work has been done, then that form would be automatically denied. But on the other side of the coin, if there were no documented impacts and it was just a status update, then we would automatically approve those forms. So using this tool in the first round, 2,208 forms were processed, and that saved about 300 hours of our staff time. So this tool is now being utilized by a select number of staff on a weekly basis, and it's being applied statewide. And then going back to the 180 forms that we received yesterday, the good news is that this tool can handle 68 of those. So we're seeing improvement from many of the operators in moving projects forward, and where that's not possible due to site-specific issues, documenting why work is on hold. So the reason that we're here today to talk about our new process that we're implementing this week, as we are reviewing forms that are not driving projects to closure, we noticed that a majority of the operators that have substantial compliance issues had a significant amount of facility decommissioning projects that had stalled after impacts were identified. So beginning this week, ECMC will be pausing the processing of Form 27 initials that are associated with Rule 911 facility decommissioning in certain situations. So staff will reach out to those operators. It's not a large number. But the criteria that are met for this are that if the operator has more than 10 out of compliance remediation projects and more than 50% of open remediation projects are out of compliance with approved reporting schedules. So this again impacts fewer than 10 operators statewide, and those operators should expect to hear from ECMC through email or warning letter if they fall below this threshold of noncompliance here. So why is this action appropriate? The facility decommissioning work, while it's very important, is generally less impactful given the nature of these facilities. So prioritizing outstanding remediation projects will incentivize non-compliant operators to return to compliance and give staff the opportunity to better manage these projects once we have the full suite of information that's required by the rules. Additionally, open and out of compliance remediations present hazards. So we've got public safety hazards, undefined impacts, open and unattended excavation in many cases. Impacts are being exposed to the atmosphere and precipitation. There may be improperly stored exploration and production waste, weeds, wildlife hazards, improper fencing, things like that. So projects such as these are often associated with complaints from landowners and local governments as well. And then additionally, the projects present a data gap for ECMC. So it makes it difficult for us to evaluate hazards that are present if non-compliant operators fail to provide required updates. So this requires additional staff resources and time to inspect locations and make attempts to determine what hazards are present and what progress is being made to drive remediations toward closure. So while we're taking that step, we're also considering how we would approach return to compliance. And we will begin processing those Form 27s associated with facility decommissionings for the non-compliant operators, again, when they meet the following criteria. So the operator will submit approvable Form 27 supplementals for 75% of their outstanding remediation projects. And these forms must provide all outstanding information for the project as well as a remediation plan for the implementation schedule, driving the project toward closure. And the operator has closed spills that are older than 90 days in accordance with our rules. So we just want to remind everybody that we expect full compliance with our Rule 913, and should a non-compliant operator revert to compliance below 75% or not achieve full compliance, that we may consider pausing additional Form 27s associated with the facility decommissioning in the future. So I think that is all of my slides. I'm open to questions if you have any.
Great. Thank you very much. Really appreciate the information for us and for the listening world. Do commissioners have questions? All right. Well, I'm not seeing questions. That means you did a good job of explaining. So thank you very much.
Thank you so much and have a great day.
All right. Next up, we have an ECMC Information and Applied Technology Unit presentation. Chris Eisinger and David Gates. And Ms. Blakeman, you might want to drop your screen share.
Bear with me one second. I'm trying to.
All right. Mr. Eisinger.
Okay, hopefully people can see my screen.
It is up, and it is now in screen share mode. So good job. Thanks.
Super. Well, good morning, commissioners. I am Chris Eisinger. I'm the Information Applied Technology Manager, and I appreciate the opportunity to provide you this update. What I'm planning to cover today, with the help of one of my group staff, David Gates, is a short overview of who we are. And then most of the time I'll be talking about where we're going, what our strategic goals are at this point, and how certain key projects fit into those goals. As far as who we are, the IAT unit, it was created in 2021. It was split off from the Permitting and Technical Services combined group. It was recognized with Senate Bill 181 and just the growth of the organization and our mission that we really needed a dedicated unit to work with technology solutions for the agency. And I was put in that position in 2021. We have 10 staff at this point. We became fully staffed just a few months ago. 4 of the positions were created in, well, 3 of them were in 2023 through legislation. Those would be the ones in purple and green. And then we had a 4th position that was part of an IT capital request this last legislative session. This group is part of this unit is part of the Strategic Services Group that was put in place at last year, and that's headed by Deputy Director Paige Papillon. We are responsible for the information systems for application support and development. Our GIS map application is one application in particular. The website, we do the technical management of that. And then we also are important for partnerships with OIT, with DNR, other divisions and the Executive Director's Office, as well as other agencies and organizations. So our strategic goals, they evolve and have changed, and this is kind of where we're at the moment with these. But really the most important one is that we're here to align our IT with the ECMC's mission and business strategy. Um, and to do that, the second goal is that we want to improve user experience for staff and stakeholders. And we're doing that through sort of three focus areas, strategic focus areas. The first being maintaining what we currently have, the current technology. The second being developing that technology, updating it to make sure that we're providing the most transparent, effective, and secure information. And then the last one is basically looking towards the future and growing and innovating through collaboration. And so we work with other units, we work with other agencies and outside organizations to make sure that we are keeping up with technology. So in the realm of maintenance, the first sort of focus area, would be keeping things running. So making sure that the database works, that our applications are working. When something does go down, we will want to fix it promptly. And then, of course, we also want to help our stakeholders in using these systems. So probably the most important one is COGIS, and this is the Colorado Oil and Gas Information System. COGIS, when we talk about our technical staff, we're oftentimes thinking of just the database, like the COGIS database. The system actually consists of not only a database, but also all the web applications that connect to it. So this would be the electronic forms, our query tools on the website, the map, and then there are some others. This is the sort of critical resource for all of us to do our jobs, and it's really a focus of our modernization and desire to improve our user experience. On the right side's a little timeline, and it's interesting to think about COGIS in the sense that it's now more than 25 years old. It was first implemented in '99, when that was the first time the agency had an actual digital database that was the archive of record. And the first, I don't know, almost 10 years of it, we would accept forms. People would submit forms, PDFs, print them out, mail them in, send them in as email, and then our staff would enter in that information into the database. Starting in 2008 is when we introduced our first truly electronic form, meaning paperless, in that the users would enter the information directly into a tool, which then would be reviewed by staff and then go into the database. There was no taking information and transferring it manually. So that was our first electronic form in 2008. From that point in time, over the next decade, we added many, many more electronic forms. And in 2019, we had a need to change our application for electronic forms to web forms for technology reasons, keeping up. At the same time that was happening, Senate Bill 181 was introduced, which expanded our mission greatly and added a lot more information that we needed to start collecting. In 2021, we introduced yet another electronic forms tool that was in large part to allow for electronic payments to be received by our users. And as of next year, we're going to actually start this modernization project, which I'll talk about in just a sec. So where does that get all that 25 years? It gets us to this figure here. And all I just want you to note is how complex this is. The databases in this whole infrastructure, we have today 6 databases. They live on 2 different servers, one internal, one external, and replication copying of information goes back and forth between them. There are more than 1,800 tables, I think several hundred views. We have more than 20 million records. A lot of those are production records. And then finally, we've got lots of automations and then integrations that go on with our web applications reports and a document management system. In other words, it's complicated what we have at this point in time. So probably the most important application that we maintain are electronic forms. And as is oftentimes said, ECMC is a forms-driven agency. Like most government agencies, when we need to collect information for our regulatory oversight, we have a form for that. Also, like most organizations, government organizations these days, our forms are all electronic, or they're very close to all being electronic. So I like to say we're electronic forms-driven agency. For us, we have multiple applications that are critical for this process to work. On this slide, on the left there, you'll see web forms and ECMC forms. Those are the two probably primary ways we collect information from our regulated community. And then we also have a e-filing system, which is what you all may be most familiar with. That's allowing for people to provide information for hearings applications and manage that data in the hearings processes. Lastly, we have some other apps that collect information via forms. And we do have about half a dozen remaining PDFs that people can fill out, email in, and then get submitted into our system. And we're working on converting those to fully electronic in the coming year. The last thing I'll just say, between all of these, there's about 60 forms, active forms. And that number is just going up as our mission expands. So we spend about probably a quarter of our time dealing with maintenance of the system. I would say we spend anywhere from 70 to 80% of our time developing, and that's what we should be doing. That's probably about right. And development goes across all these applications and updating the database and whatnot. And the first sort of key thing I want to mention or update you on is that we have a modernization of our COGIS system that's been put into play through a process last year. A capital IT request was put in and approved. This has a roughly $2 million budget. We're looking at a 12 to 18 month duration for this project. And really what this project is going to be focused on overhauling the back end, so the database environment. What we're wanting to do is move this to a cloud-hosted environment. Clouds have benefits over traditional on-premises hosted databases. We want to really get in and review the database architecture and simplify it. We want to look at the schema and the model to remove redundancies, make sure our data typing and everything is optimized. When we do this, one of the things we'll have to do is update the applications that connect to as well. And I think an additional phase of this work that we are already planning for and anticipating is to work on the front end. And so that would be all the applications, including the electronic forms. This is just a simple figure to show you when the databases today, we have, like I said, 6 databases that are replicated back and forth. In the future, we're going to try to simplify this to be just sort of a single stack, and it'll be hosted in the cloud. With regards to electronic forms development, this is probably one of our major pain points is the speed and velocity at which we can develop and implement new forms. And so we are very much focused on process improvement with the establishment of the Strategic Services Group and also a new QA/QC group. This has really become a priority. And the improvements we've already made are we've added new positions to my unit in QA/QC. Through the help of our leadership, Paige, through EDO, DNR, Amy Clean, and then others at OIT, we've implemented agile development in our eForms process. We've created an SOP for how we develop electronic forms on the business side, and notably including more robust change management. I think change management has been lacking, and we've really beefed that up and made that better. And then lastly is trying to do better knowledge capture and sharing of our information amongst our team. I think one of our major highest risk areas is that we've got individuals who know everything, and when they leave, we're left with a vacuum, and it can be very difficult to react to that. So we're trying to exchange information and document it better going forward. So where are we with our electronic forms currently in development? This table on the right kind of shows the active backlog. And immediately, what we're trying to prioritize is forms to support produced water rules, getting those implemented, statutory alignments. The field inspection report has need to be updated for a while, and we're working on getting that done. And then finally, there are a number of forms associated with ECMC taking on Class 6 primacy. And so we've been working with subject matter experts in the various units to design these. We template them, and then my team reviews them and gives them to OIT application developers to actually create the forms. In the midterm, so into sort of the middle of next year, we'll look at changes to financial assurance forms, as well as, like I mentioned before, creating electronic forms for the remaining PDF forms. And then the long-term development is going to be focused on migrating of all the web forms to a more capable and newer application, perhaps the ECMC forms, perhaps another application. The last area that I'm going to talk about as far as development or project areas is on our COGIS system audit tools and reports. So these are the tools that allow our staff, the industry, public to search and interact with the data. Our team specifically develops and supports these tools. And I want to just go through some highlights of some. I'm not going to go through all of them, but this is ones we've been working on actively over the last 6 months to a year. The first is financial assurance. We've done a lot of work to improve financial assurance tracking. This is a report on the right there, screen capture what's available to ensure accuracy, and it's up to date. For the financial assurance team at QA/QC, we've worked on Form 1 reports recently. This is the operator registration and management of their agents and their contact information. In Form 1Bs, which is for annual reporting of like mitigation fees or general liability insurance, we have reports to ensure that they're compliant and up to date with those. And lastly, also in the financial world, the reviewing of contributions is something that we've tried to make better for the financial assurance team so they can audit that. A second area of these tools and reports is responding to and working with a recent OSA audit, the state auditor's office. This, I think, report was just released earlier this week, where they looked at our oil and gas reporting, specifically our production information, levy information, emissions. And what we're working on, or will be working on, we already have a plan in place to respond to it, is to automate how we capture our delinquent reports for production, validating against other sources of information for conservation levy, and then ultimately create better tracking tools. And this is, again, a work with QA/QC and the enforcement units to ensure that our operators are compliant with the reporting. Last year, almost a year ago, we introduced a chemical disclosures tool, and this allows the public or anyone to search based on location, API, operator, to look at what is in the chemical products that are being included in the drilling operations. And this is still a work in progress as far as I think there's a possibility of adding more information to this, but I think the tool itself is very useful for someone to get a assessment of a particular location or site and what's being used. And then lastly, I'll mention a produced water data information, which has been added to our Scout cards or well information page. So it used to be we just showed oil and gas data. Now that we're collecting produced water information, that is also available for the public or others to see. So with that, I will pass it off to David, who's going to talk about our map application.
Yeah, thanks, Chris. I'm David Gates. I'm the GIS coordinator here at ECMC, and I'm going to talk about our new map. So why the need for a new map application? Our current map has been in use for about 20 years, and the software that's running it has been deprecated, no longer supported by our vendor, and causing some issues, some back-end pain points with keeping our data up to date and running smoothly. And as with anything, more data coming in, more information, there's a need for something new with updated functionality and more interaction with the data. We've been working with a contractor over the last year and a half, 2 years to get this new application built up. We are striving to continue to serve the same functionality as the current map, plus some new helpful features such as the data filtering, robust querying, data export, interaction with the data through the data tables, and the ability to add your own data on the fly to the map. We will be testing through January or through December. We have a target for January, assuming everything goes smoothly. And then I have a quick little demo here that's showing off one of our new features, the ability to filter our data on the map, not something that we've been able to do up to this point. So you'll see here with the wells data, I'm able to set a clause and set the well status and the operator to get a filtered subset on the map. You can view that data in the data table, and then you can also export it. We'll have various options for what you can export to, but here I chose CSV, so it's an easy way to get it onto your own machine. And that filtering option is going to be available on any of the layers that we have in the map, so it'll be a super helpful feature. Along with the new map application, it's all built in Esri's enterprise environment. This is going to allow us to be more integrated with the rest of the DNR GIS groups. We'll have a page that'll serve as a data hub for downloads and quick access to the other agencies within DNR for their data and their map viewers. And as far as backend infrastructure goes, we're going to be able to share our resources with them, servers, and all the neat things that come with Esri. And with that, I'm going to pass it back to Chris.
Thanks, David. So I just have one more slide. And this is on that last strategic focus area, which is collaboration. We have a number of areas we collaborate on, and I'm just going to highlight 4 here. The first is website development. I think you all have seen some presentations this past year about our new website. This is a work with community relations and now the strategic development unit as well. Our goals with our website are better communication, accessibility, and we're looking at adding new tools, I think, in the coming months to that dashboard or to that website. One of which will be our dashboard overhaul. I think you're all familiar with the DAD, or at least have heard of it, and so that's a goal of ours, is to update that and make it more useful and easier to use. Second area of collaboration is with data integrity. That's very important to us. It's also important to most units across the agency. We've been working with the environmental unit on audit tools for them. In particular, data falsification issues came up earlier in the year, and we've been consulting with them on that. We've been working with the QA/QC unit on automations and improved workflows for their purposes, especially in financial assurance, as I alluded to previously. In the area of artificial intelligence, it seems like everybody's talking about artificial intelligence these days. ECMC has put in place an AI exploratory committee. We're almost coming to the end of that sort of project. And the whole basis for our committee is for ECMC to look at how we're going to use AI strategically. We're proceeding with caution. We're trying to understand what the risks are and how we might mitigate them. I think AI is one of those areas where there's a lot of useful things that can be done that will improve the agency's effectiveness, but there are also risks that come along with using that. So we're trying to proceed very carefully with that. In artificial intelligence, we do have had a pilot project that's going on that is leveraging AI to improve the quality of data submitted on Form 19s and Form 27s, and also to improve the efficiency of the review process. I think there's a lot that will be going on in AI in the future. And then lastly, the data access and transfer. We work with a number of organizations to facilitate better data access and exchange. In particular, CDPHE, we've been working with them on how to better exchange emissions data. That's an ongoing project. There's a lot of challenges in doing those sorts of databases links, especially when they're completely separate systems. With the Water Quality Control Division, we have been working with them to ensure that our surface water protection map data is current and accurate. And I think that's been a good collaboration. For industry, the regulated operators, we are actively looking at creating an operator portal for field inspection reports, allowing them to look at the field inspection reports and manage them all in one place. We're also always looking at processes for them to more efficiently provide their data to us. With that, I welcome any questions or comments you might have.
Thank you very much for the presentation. A lot of good information. Questions, commissioners? Commissioner Messner?
Thanks, and thanks, Chris and David. This is really good information for me, and I think it's fascinating to see how this information has evolved over just the time that I've been here, and I haven't been here that long, right? 6 years, and but to see how this has evolved and the technology has evolved and the amount of information that is being compiled and digested and provided to all the different departments, and it's really impressive stuff. And so I want to give you guys props for really reimagining how the technology is being utilized in this agency, and the amount of information I have to think is just overwhelming. But I think that you guys have handled it well, and it's really cool to see it continue to evolve, and I have to think that we're leading agencies in the state on this, and so really impressed with that. I did have one question, and it's a curiosity piece, but as we look to try to develop data both for the utilization by the agency, by the regulated community, but also the public, I keep hearing about the benefits associated with story maps. And so I wonder if you could share a little bit about your thoughts on story maps, and how they may be able to be utilized to create digestible data or information for folks.
David, do you want to respond to that?
Sure. Yeah, so moving our map platform into the Esri environment, we're going to have access to all the Esri products, story maps included. And I think they're great. They're great for telling a story about something super complicated, and you can embed, say, the maps or data. You can embed a lot of stuff into them. And kind of display it that way. And I think that's a really good use of that technology to put it out there. It kind of leads somebody through the thought processes, or kind of how things are done in a more of a graphic way, with some real world examples of things that are maybe harder to put into words.
That's great.
And I would just add, Commissioner Messner, that a story map is helpful because telling something in a spatial context is oftentimes much more understandable, especially for a lot of the data we work with. So that's what a story map excels at, that you can tell a story through spatial information.
So as we continue to evolve these platforms, that becomes more of an opportunity for us to be able to utilize that technology.
Yeah, exactly. That with Esri in particular. Yep, that's right.
Well, thanks. Appreciate the presentation.
Yeah. Any other questions? All right. Thank you both. Go forward. Continue doing all the great work that you do.
Thanks so much. Appreciate it.
All right. Let's take up the next docket. I think it's pretty short, and then we'll take a break before we go into executive session. That's docket 2408-00190. Pooling exception. Applicant is Verdad. Resources. Petitioner is Civitas North. Today, we are to deliberate on whether to grant oral argument on the petition and the response from the applicant. Does folks desire to see oral argument on this? Commissioner Messner?
So I believe that the information that was provided in the written documentation certainly provides a depth of information for me to be able to make a determination on this. But I'm never opposed to oral argument. So if anyone has any strong feelings one way or another, I'm certainly happy to hear short oral arguments on this. But I do think that there was a lot of information provided in the written submittals that make me comfortable to be able to make a decision either way.
Commissioner Cross?
Thank you, Mr. Chair, and I'm in agreement with Commissioner Messner. I do think that the information in the written documents is sufficient. However, I'm also always happy to hear oral argument. It provides another opportunity for questions to be answered as well, should they arise. And so I'd be fine with oral argument.
All right. Then I would suggest maybe we grant oral argument, maybe 10 minutes each side. I think it's for December 17th, our next agenda. And we will, if folks are okay with that, I would move for a short oral argument in this docket on December 17th. Do we have a second?
Second.
Motion and a second. Further discussion? Seeing none, all those in favor signify by saying aye. Aye. All right. AAG Boudreau, if you could, why don't we go ahead and do our motion to enter executive session, and then we'll take a break, and then we'll go into executive session in the other Zoom meeting, and then come back. So let's kind of tee that up before the break, if you could.
Sure. Pursuant to open meetings law, the commission is entitled to enter executive session at this regular meeting to receive legal advice pursuant to Colorado Revised Statutes, Section 24-6, 402, 3A2. During the executive session, the commission will receive legal advice as described on today's agenda regarding ECMC docket number 241200313. Mr. Chair, you can entertain a motion to enter executive session for the matters and purposes I just described.
I will entertain a motion.
So moved.
Second.
Motion and a second to enter into executive session as described by AAG Boudreau. All those in favor signify by saying aye.
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 Any opposed? All right. To the 109 people that are listening in, what happens next is the commission will go and leave this Zoom meeting. We'll go into a separate Zoom meeting for executive session purposes with our attorney. We'll undertake that executive session, and once we're done, we'll come back here. We're also going to take like a 10-minute break before we go into executive session. It's always hard to tell how long it's going to take, but I would suggest maybe about an hour. But just stick around and we'll be back here for deliberations in docket 2412-00313, probably beginning about 11 a.m.-ish. So with that, commissioners, we'll leave this meeting. Let's return to the executive session meeting at 9:55, and I'll see everybody there. All right, Colorado Energy and Carbon Management Commission is back in session, and we will look to our AG to pull us out of E session.
Thank you, Mr. Chair. We are returning from executive session. During the executive session, the commission received legal advice regarding ECMC docket number 241-200-313. No decisions were made and no votes were taken. Mr. Chair, you can entertain a motion to exit executive session.
So entertained.
So moved.
Second.
Motion and a second to exit executive session. All those in favor signify by saying aye.
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 All right, we are out of executive session. With that, we will take up docket 241200313, a oil and gas development plan proposed by Crestone Peak Resources. We have two petitioners, Maverick Mineral Partners number 2 LLC, represented by Stephen Lewis Prescott. We also have Save the Aurora Reservoir, represented by Michael Foote. Commissioners, so we're going to start into deliberations on this OGDP. I think it might make sense for us to deliberate without deciding, but kind of get our thoughts out there on the Maverick petition first, and then we can turn to the merits of the OGDP. The Maverick petition has to do with competing points relevant to DSU and spacing issues. And so I would look for commissioners to start the deliberation on Maverick. Commissioner Cross.
Thank you, Mr. Chair. And I'll kind of wait on some of my, we'll call them introductory comments until we get to the OGDP part. I'll start off saying, I think for me, this is not an issue of whether the commission can create or can adjust a DSU, but should it? And simply put, I do not support adjusting a DSU for a single party, single mineral owner, when doing so would create potentially adverse consequences. It's important to note that DSUs will always have minerals just outside the DSU. The point of the creation of the DSU is to ensure that the minerals within a common pool are efficiently drained and mineral owners are equitably compensated. There are two issues to address here: waste and correlative rights. Here, Maverick purchased mineral rights after the initial filing of the CAP application, hoping to benefit from an existing plan to develop. The purchase of these rights are not guaranteed. Just like other investments, it carries risks, whether development does or does not occur, whether permits are approved or not, or whether the well ultimately does not produce. After they purchased the mineral rights at issue, the applicant modified the CAP boundaries. Maverick alleges that this is some sort of personal attempt to keep Maverick from benefiting, but I think the testimony showed that's simply not the case. As Arapahoe County modified its rules and setback requirements, Crestone could not feasibly develop the acreage in question from its proposed or alternative sites. Therefore, they modified the application. I think of note, as Crestone testified, it would benefit them to be able to develop that land, but they could not do so. The acreage was removed so the minerals that could be developed would have appropriate compensation. That is protective of correlative rights. Including acreage that will not be drained would result in mineral owners getting less than their fair share of royalties. The inability to have a viable location here goes to waste. Maverick's arguments essentially work against themselves. The fact that there's not a viable location shows that the alleged waste of not drilling is because of concerns for protection of public health, safety, welfare, environment, and wildlife resources. Senate Bill 19-181 changed the meaning of waste. It is no longer waste if minerals are not developed because it cannot be done in a protective manner. Maverick's arguments to include the south half of Section 18 are frankly not convincing. First, Maverick does not provide a viable solution here. Maverick's request to solve their concern, and theirs alone, ignores all other mineral owners within Section 18. We as a commission must address the rights of all mineral owners, not a single mineral owner. Second, the engineering arguments are not persuasive. Testimony showed that these minerals would extend 650 feet above the border of the proposed DSU. Looking at the engineering testimony of the applicant, the frac wing, or half length as it's called, would be between 250 and 290 feet. This is consistent with numerous operators in the basin, and more importantly, consistent with state spacing buffers. I'll get to the drainage shortly, but the bottom line is that to drain 650 feet, the northernmost wellbore would have to be approximately 300 feet north of the DSU, which is approximately 920 feet north of the northernmost well as currently proposed. Even if the deflection south as proposed does not occur, that would still be 680 feet north of the northernmost well. That spacing creates enough space for an entire additional well to be drilled within the spacing in the DSU, based on both state spacing assumptions as well as frac lengths shown by numerous operators in this field. To properly drain, the applicant would either have to add an additional wellbore or increase the spacing throughout the DSU, resulting in potential waste due to the increased spacing. Understanding that the feasibility of drilling to the minerals would be in question, Maverick provided an alternative argument. Don't do anything different, but include us in the DSU because you're going to drain us anyway. The arguments that all these wells will drain up to 1,300 feet is simply not convincing. The production data shows that the farthest child well has an additional production Maverick's production data suggesting that the farthest child well has additional production in non-analogous situations, i.e. wells without the same level of step out, without the same lateral length, is not proof that drainage reached 1,300 feet. Indeed, the farther you get from the wellbore, the more friction you have to overcome. So the more you lose drawdown forces due to friction effects. Thus, the differential pressure will decrease and drainage will decrease. A good way of thinking about it is if you had a vacuum and you kept putting extenders on it, the further out you get from the vacuum, the less suction you're going to have. If drainage occurred to the extent suggested by Maverick, our engineering group would drastically alter the state spacing and DSU buffers, even if only at the very toe of the wellbore. But they don't. More importantly, if the draining suggested by Maverick were to occur, all operators, would adjust their spacing and drill far fewer wells and or change the configuration of DSUs. But they don't. It's because this kind of drainage does not occur. So ultimately what you have here is a situation where they're saying it's waste because we don't have a viable location. Under the definition of waste based off of Senate Bill 19-181, that argument works against itself. So then you have to look at the correlative rights. And I think quite simply, you're not going to have the drainage. You're not draining Maverick's minerals under the proposal. And therefore, I don't think that that's a concern about correlative rights. And to actually include, as Maverick suggests, in having the south half of Section 18 would increase what's actually going into the common pool of all those. And so because there's unlikely to have drainage of those minerals, you're actually going to have a problem with correlative rights for those within the actual cap boundary as currently proposed. So I'm in support of the proposal to tighten the spacing at the end of the northernmost wellbore to ensure that no drainage would occur, which is consistent with our rules. The bottom line, the proposed DSU and spacing is consistent with both state rules and assumptions and operator data, not just this operator, but all operators in this field. It shows that no additional wells will need to be drilled. Minerals within the DSU will not be wasted, and no minerals outside the DSU would be drained without compensation. The protection of public health, safety, welfare, environment, and wildlife resources will be addressed separately. But to reach a different conclusion would put other DSUs in question throughout not just the walk-in field, but the rest of the state. And therefore, I would propose denying the Maverick application because I don't think there's any issues with waste or correlative rights based on the proposed DSUs.
Thank you, Commissioner Cross, for the deliberative thoughts. I appreciate you setting the stage for the rest of us to bring in some thoughts. Anyone else with thoughts? Commissioner Messner?
Thanks, Mr. Chair. Thanks, Commissioner Cross, for leading us off and providing your thoughts. And I would agree that the topics here are waste and correlative rights. I think I have a little different perspective, and certainly I'm open to other commissioners' thoughts on this as well, because I do find these things, the OGDP application and the CAP application and the petition by Maverick are intertwined. and it is a little difficult for me to separate them, but I'm going to do the best that I can. But I think one thing that is important to me is that Crestone, as the applicant, applied for a comprehensive area plan. And so comprehensive area plans are designed to look holistically and be a comprehensive planning tool. And, most of the time we see comprehensive area plans that include preliminary siting in order to be able to work through these issues comprehensively at the comprehensive area plan planning stage and take the time necessary to work through these issues so that we have OGDPs that come before us that are comprehensive in nature, that have looked cumulatively at all the potential public health impacts, but also the correlative rights and waste issues associated with having the benefit of the mineral aspects of the comprehensive area plan. And I think that the challenge here is that the comprehensive area plan was brought before us without preliminary siting, without the benefit of having Arapahoe County fully having developed its local government regulations to determine potential siting, and to see significant modifications of what was initially contemplated from a drilling and spacing unit concept in the comprehensive planning phase of the CAP application process to be changed based on changing regulatory requirements from the local government, and therefore not only potentially stranding Mavericks Minerals, which they are the petitioner in this situation, but potentially stranding significant other mineral owners in that particular area because of the lack of comprehensive planning that was done in the CAP stage, and I guess the rush to come to a decision on the CAP before some elements were settled in order to be able to develop preliminary siting at the CAP stage. Now, applicants have the ability to request a CAP without preliminary siting, and I acknowledge that, but these are some of the things that may happen when the time's not taken to fully utilize the philosophical concept of a comprehensive area plan, which is, evaluating and addressing cumulative impacts both to public health, safety, welfare, the environment, and wildlife resources, but also to correlative rights, as well as using it as a comprehensive planning tool to really look holistically at how minerals are going to be drained, as well as how avoiding, minimizing, and mitigating potential impacts are going to be addressed. And so, I think it's the responsibility of someone who is applying for a comprehensive area plan and the associated OGDPs to engage with not only the community and CPW and CDPHE, but mineral owners in looking at how they're going to develop their drilling and spacing units, and how they're going to address waste and correlative rights. And so I think it's a little bit of a challenge for me to look at this one, because I do think that in the rush to make a shift based on changing local government regulations without fully understanding the potential the potential of where different sensitive receptors were going to be and what different surface owner requirements were going to be from a tier structure, and understanding the different alternative locations that could be evaluated that may have resolved this issue before it coming before us in an OGDP. I have some questions on whether or not that was adequately handled by the applicant. And so those are the things that I think about when I'm thinking about this argument. I think there's potential solutions here that maybe haven't been evaluated or fully looked at. And so I'm not sure exactly where I'm at right now, but those are my deliberative thoughts right now. I'd like to hear other commissioners' thoughts on this one.
Commissioner Oath?
Thanks. I think I'm gonna keep my comments focused on the issues of waste. So when I'm thinking about this, starting clearly with the fact that as the applicant, Crestone carries that burden to demonstrate that the proposed DSU complies with the statute and the regulations, and therefore, that includes demonstrating that this DSU would not result in waste of Mavericks minerals. And I guess as I think about this, I think Maverick may have a point that finding a viable and approvable surface location to develop its minerals may not be possible because of the various setbacks and because it may require drilling in a location that could have significant public health, safety, welfare, and the environment implications. Um, However, it may also be that in order for Crestone to develop these minerals, Crestone would need to change the proposed surface location to one that is even further to the west or closer to the Aurora Reservoir or closer to more RBUs. And so if that were the case, then, such a location would, potentially be too impactful to public health, safety, welfare, and the environment, such that, non-development of the minerals would not constitute waste under the statute. So I guess where I am currently is, recognizing that there was some information in the record on this, but feeling that it could be further developed, and I'd like to see it further developed prior to making a determination on whether or not this proposed DSU would result in waste. So that's where I am.
Well, I can weigh in. I tend to agree with Commissioner Cross and his points that there's not waste, that there's not correlative rights. I appreciate the sort of reverse proposal on that. And I appreciate that, Maverick made an investment. Um, and I appreciate the fact that the location we're looking at uh, creates, I think more difficulties for all the minerals to be developed, and it's not waste if we're trying to be protective. So I would be a vote to deny Maverick's petition. Leaves you, Commissioner Ackerman.
Thanks, Mr. Chair. The bottom line for me too is I'm not generally supportive of the Maverick petition. From a drainage perspective, what it comes down to for me is that it's tough to require compulsory cooperative action upon any operator based upon an unproven and not widely accepted setback distance of 1,300 feet, absent significant broader independent evidence suggesting it's appropriate to deviate from, previously established engineering and norms. For me, this hearing marks the only time I've been presented that potential setback distance since I've been on the commission, certainly, and the only time ever, so far as I'm aware. I think we would need a lot more information to deviate based on the drainage issue. And to this point, I'd state that I don't generally consider a witness contracted and presumably compensated by one party an impartial witness, as was at times asserted on this issue in this case, but rather that witness, while expert in his or her field, is tasked with presenting that party's best case. From a stranding standpoint, it's a little more difficult, I think. The lack of an available location argument is difficult for me. Maverick argues that it might not be able to find a viable location while simultaneously arguing that another operator extend its reach from its own presumably approved viable location. It is admittedly much more difficult and more disruptive for another location to be put out there specifically to extract these minerals. But from a stranding perspective, I particularly am concerned that you've got other minerals, as Commissioner Cross mentioned in that section, that also can band together and talk about how to work to get all the minerals out at once. And so, while I think there are problems, Colorado is not a state of compulsion. And while there might be opportunities for Maverick and Crestone to cooperate on extraction of minerals, they've clearly not been able to come to a mutually acceptable agreement. So for me, the bar from my perspective is pretty high. That a strong and compelling argument would need to be made in order for me to obligate one private operator against its will to execute the work of another private operator, even implicitly through a pooling order. That said, I did want to note that from a process perspective, as was eloquently pointed out by you and my fellow commissioners, intertwining a DSU plan with an OGDP as it's contested creates a myriad of issues, including proper and clear description of impacted areas, engagement of the proper mineral owners, community members, and jurisdictions, to say nothing of the legal vulnerabilities associated with rulemaking notices and other Administrative Procedure Act requirements. For me, the best solution in contested pooling issues is likely always attempting to separate those from OGDP decisions, even though they are related, continuing to encourage the parties that are applicable to work together to ascertain whether they might be a mutually beneficial opportunity. And if such an agreement is struck, certainly the pooling order can be jointly proposed. If such an agreement is not struck, I think the appropriate approach is for both sides to present their competing pooling orders and make arguments for them for us to be able to assess and address. So given the information that we've been provided and given the testimony, I also lean in favor of dismissal of the petition.
All right. I started off process-wise thinking we should do some initial deliberations and then move to the OGDP. Don't want to cut anybody off. Does anyone have, but I also don't want to get to a vote on Maverick at this point. I want to sort of do all that at the end of the deliberations. So are there others with an additional deliberative thoughts at this time? Or is everybody comfortable with kind of where we see each other? And then we would move to the OGDP itself. All right, seeing no further deliberative thoughts there, I think next we need to take up deliberative thoughts on the OGDP at this point and look forward to hearing from folks on that front. Commissioner Ackerman.
Thank you, Mr. Chair, and I appreciate this. This has been a very involved and long OGDP for many people, and I wanted to express appreciation for all of the involvement in this OGDP issue. It's a difficult application that's promoted significant participation from the public, from STAR, from other potentially impacted parties, including other minerals owners, as we've just talked about. And I've mentioned a couple of times in previous hearings the difficulty stemming from the dichotomy in overall desire for oil and gas development under this cap on Lowry Ranch. And to me, those previous statements hold true in this hearing. On one hand, you have proponents, the State Land Board, who's the state agency that's the landowner, with missions of providing resources for schools and ensuring proper public land stewardship. The city of Aurora has weighed in, and while not necessarily in favor, they've explicitly stated that they have no concerns for the well-being of Aurora Reservoir associated with this application. And most notably, and what I wanted to focus on just a little bit, is the support of Arapahoe County. And I'll hit that just a little bit lower. But on the other hand, opposition's been expressed by virtually all commenters from all hearings, mostly comprised of impacted citizens of Arapahoe County, which, as I've noted, is a county who is overall supportive of this application. I also wanted to note that there were comments in an earlier hearing by Colorado State Representative Eliza Hamrick, who's the elected State House representative for House District 61, and that's the district that represents the residents, those same residents in Arapahoe County at the state level, and remind everyone that she explicitly advocated for outright denial of this application. So I wanted to touch again, although I've done it a bit on the past, on the roles and responsibilities of some of the entities here. The State Land Board is the landowner. They do have the mission, as I've mentioned, of supporting schools, which has come up a number of times here, and stewarding land. They also have their own board, their own processes, and they've long not only approved, but advocated for oil and gas development on Lowry Ranch. This is not a hidden use of this property. Local governments, as I've noted before, the local government body is elected by the citizens of that county, specifically to represent the desires of those citizens as a whole. and they're the primary land use planner and regulator within their jurisdiction. So to me, in general, local governments operate with broad discretion, explicitly and specifically to represent and implement the collective will of their residents, which is an important distinction. As such, local governments are in the best position, as far as government entities go, to implement their citizens' desire for desire's sake alone. For ECMC, we establish energy and carbon management rules within our statutorily allocated subject matter jurisdiction at the direction of the legislature. We also ensure compliance with those rules, and we're tasked with providing consistency and predictability for operators who work in a complex business and regulatory structure. And I think it's important to note that our decisions are all subject to judicial review. As a government entity, ECMC is beholden to the will of the residents of Colorado, yes, albeit largely as directed by and through the legislature, which is composed of senators and representatives such as Representative Hamrick. To implement the collective will of the people of the state as a whole, they give us direction through state statute, which results in implementing and enforcing policies, rules, and decisions that are then subject to that judicial review process. And what judicial review entails is once we take a formal action and a judicial review process is initiated, a district court reviews whether or not we as a commission have followed the act and our rules in any formal action that we take, including our reasons for approval or denial of an OGDP. So for us to deny an application as advocated by Representative Hamrick, and have that application denial upheld through judicial review, that action must reasonably demonstrate lack of compliance with ECMC rules or the act. So that's why you always, often at least, hear us say that compliance with ECMC rules and the Oil and Gas Act, from our perspective, is the primary driver of our review of applications. That said, I certainly have heard and understand the concern and trepidation from the directly impacted public on this application. And I wanted to kind of doing a sidebar and make an editorial comment on public input. I've read and listened to the multitude of public comments. This is the broadest public engagement I've seen since sitting on the commission. We had the 511 hearing, we had other written and oral public comment. Excuse me. And I wanted to express appreciation for the level of attention and involvement that this proposed project has received from impacted, interested Colorado residents. This type of input is often very conducive to hammering out difficult issues at our level. And I did, though, want to share a few points on public comment. I would just note for all those listening that from my perspective, a campaign of broad copying, pasting, and emailing of the same letter is not a particularly effective form of advocacy in my review of an application. I certainly read such form letters and I note each signer, but I generally regard that as one viewpoint by one person or one group who's initiated a signature type campaign. Individual letters expressing personal viewpoints and concerns are much more compelling, and I certainly appreciate those that were submitted. Even more ineffective is insulting, threatening, degrading, or inciting language or behavior. I would argue that this is counterproductive to any desired goal. And while there were many great comments at the 511 hearing for this pad, we saw some regrettable behavior there. And I want to make clear that I don't give any weight to commenters that take this approach or that attempt to use their time at the microphone to incite public ire or riotous behavior. To be clear, I'll note that this philosophy doesn't extend to commenters who rightfully, respectfully, and directly, even vehemently, express frustration, trepidation, anger, or fear. The great preponderance of the comments at the 511 hearing were direct, but they were of this respectful nature, and I hear those commenters and strongly consider the points they make. So due to the role of the commission, as I outlined earlier, because we enact the will of the people of the state as a whole as directed by the legislature and implemented through ECMC rules, the most effective comments from my perspective are those that specifically highlight regulatory or statutory deficiencies of public health safety, rather than those that simply make broad assertions of lack of protection of public health, safety, welfare, the environment, wildlife resources, or that just express a general lack of desire for a development. Those are difficult for us to handle while considering the judicial review nature of our decisions. Most effective to a process that may undergo judicial review are those comments specifying how proposed applications are deficient or otherwise non-compliant with statutory, regulatory, or policy language. So I just wanted to make that comment since we've had a lot of public comment associated here for those that are listening and want to comment in the future. So to the pad itself, while I might discuss my thoughts on wildlife and a few other items a bit later, depending on how our deliberations go, I really just want to cut right to my primary points on this application. During the CAP process, we made clear that the CAP planning stage was not the approval stage for this pad, but rather that the scrutiny for approval to drill would come at the OGDP stage, which is where we are now for the state Sunlight Long pad. During the CAP hearings, I noted that the placement of the proposed well sites very near the boundary of the Lowry Ranch property, rather than the interior of the property, was troublesome to me, as it unnecessarily, and I emphasize unnecessarily, minimized the distance of the surface locations from dense residential development. I specifically noted that the Sunlight Long pad was a concern to me for this reason, and I stated, quote, "If this CAP is approved, I would expect there to be significant continued and ongoing efforts to work with county leaders and the community regarding practices that are found to be acceptable to the county and to the community as a whole during its future consideration of oil and gas specific sites. Specifically, I'd be looking for continued best efforts to minimize impacts on residents, especially on the state Sunlight Long pad." End quote. So, Commissioner Messner pointed out a little bit earlier kind of what CAPs are for. 314A1 states the commission intends for comprehensive area plans, CAPs, to facilitate evaluating and addressing cumulative impacts from oil and gas development in a broad geographic area by identifying plans for one or more operators to develop oil and gas locations within a region while avoiding, minimizing, and mitigating impacts to public health, safety, welfare, the environment, wildlife resources in the region through systematic planning of infrastructure location, best management practices, and centralizing facilities. In the statement of basis and purpose, it's often stated that the CAP is intended to minimize impacts. On page 109, it states, CAPs are intended to facilitate the evaluation of the cumulative impacts of oil and gas development over a broad geographic area, and to address those cumulative impacts by developing infrastructure and other planning tools throughout the area in a way that minimizes surface disturbance and other adverse impacts. Testimony and the OGDP application materials demonstrate to me that despite the Commission's encouragement to work with the community, the proposed Sunlight Long application PAD has not materially changed since approval of the CAP, other than in specific responses to consulting agencies or internal operator desired enhancements. So as such, it shouldn't be any surprise that my feelings towards the location of this pad, the largest pad in the CAP and the pad nearest the highest density of homes, haven't changed since the CAP hearing. To me, the question most prevalent as I've considered this application in light of the CAP hearing is, can the commission staff and the operator confidently state that we found the best location for this pad? Or have we simply found an available location that complies with setback rules? And so in pondering this, I've thought, what does the best available location mean? It's been pointed out numerous times during the Lowry Ranch proceedings that this concept is embedded in the ECMC mission. The best location is one from which minerals can be extracted while most protecting against impacts to public health, safety, welfare, the environment, and wildlife resources. And from my point of view, that mandates a utilitarian pad location search approach, or rather an objective examination of which feasible site does the greatest cumulative amount of good when all of these factors are taken into consideration. That's the specific intent of an alternative location analysis, or ALA. So on the point of ALAs, the mission change statement of basis and purpose, page 77, states, the purpose of the alternative location analysis is to create a tool for the commission, its staff, and the operator to use to identify the best location to avoid adverse impacts to public health, safety, welfare, the environment, and wildlife resources. So I want to state my disappointment in not just the inadequacy of the ALA that was provided, but really in its very tenor. And it didn't go unnoticed by me that in response to community concerns raised by a group whose name is Save the Aurora Reservoir, Crestone's alternative location analysis brazenly suggested two alternative sites, both of which are much closer to that reservoir than is the proposed site. So close, in fact, that those locations would clearly and with foreknowledge not be permissible under existing Arapahoe County reservoir setbacks. As noted during the hearing, the other location, ALA 1, that was examined farther to the east was suggested by Starr. We heard Starr criticize this ALA as incomplete, and we heard them ask if Crestone's regular business practice was to select ALA sites for analysis that are patently unapprovable in order to bolster its preferred location. And I would echo that question. It's been repeatedly reiterated during the CAP hearing and in many communications since then that protection of the reservoir is a primary concern of the affected community. I personally find this approach by the operator to be in direct conflict with the direction I provided at the CAP hearing, essentially the opposite of, quote, significant continued and ongoing efforts to work with the community regarding practices that are found to be acceptable to the county and to the community as a whole, end quote, and also in direct conflict with, quote, best efforts to minimize impacts on residents, especially on the state sunlight long pad, end quote. So I think Crestone's ALA approach was objectionable on its face, as it not only failed to demonstrate an effort to work with the community in response to their concerns, but conversely appears to suggest zeroing in impacts on one of the community's primary resource protection concerns. And while I concede that I don't know the motivational intentions of Crestone's ALA, I find their approach on this important issue to be obtuse at best, given the input of the impacted public and the direction that we provided during the CAP hearing. So to the point of alternative location analyses, Reg number 304B2C states if an alternative location analysis is required, the operator will prepare a narrative analysis that identifies all potential alternate locations from which the targeted minerals can be accessed that may be considered for siting of the oil and gas location. Emphasis on all. Now, notably, an ALA was not, as has been pointed out a number of times, automatically triggered for the sunlight long pad under the criteria of 304B2B. This ALA was not required, but it was initiated and conducted voluntarily by Crestone. So therefore, as I've made clear, I believe this was an anemic and objectionable alternative location analysis. I personally don't see a pathway for denial based on an insufficient ALA alone. I would note Crestone's approach on most other points of this application is actually quite strong. But nonetheless, the selection of patently unpermittable sites certainly makes it dubious in my mind whether or not other workable locations were actually earnestly sought, and whether the proposed location is objectively the best location for the sunlight long pad. To me, the reality is that this is a relatively unique situation when it comes to the potential for surface location of pads. Ordinarily in OGDP applications, oil and gas surface location alternatives are very restricted due to patchworks of multiple parcels of private land with different landowners, as well as existing infrastructure and other development necessitating multiple special use agreements, setbacks, rights of way, and infrastructure avoidance measures and practices. In this case, outside of the State Land Board's management plan, normal surface location limitations are virtually non-existent. The fact that this development is taking place on the property of one large, contiguous, and very willing landowner, to me creates ample opportunity to examine and select the best location for this pad. Senate Bill 19-181 focused on ensuring that alternative location analyses applied to, quote, oil and gas locations and facilities proposed to be located near populated areas. That's going to be found in Colorado Revised Statutes 34-60-106 11C1. So I believe there's ample opportunity to, again, quoting the direction I gave at the CAP hearing, minimize impacts on residents, especially on the state sunlight long pad. This can be accomplished by Crestone examining locations for this pad farther away from the dense residential development along the boundary of the property. The operator has heard throughout this public process, many of the residents state that their concerns diminish significantly for the entire development if this one specific pad is shifted farther east toward the interior of the Lowry property. Now, while an ALA was not automatically required for this OGDP, Rule 304B2A2 provides an opportunity for the Commission to order a more comprehensive alternative location analysis. It states, for any proposed oil and gas location not subject to Rule 304B2, which is the automatic trigger, the Director may require additional information, including an alternative location analysis where necessary and reasonable, to evaluate whether the proposed oil and gas location complies with the Commission's rules and the Act. There have been significant and numerous assertions from the impacted public that the proposed pad is not compliant with the Act, specifically the protection of public health, safety, and welfare. And absent the conclusions of the ongoing public health work group that we have in time for this application, the impacted public has requested that the operator at least examine locations farther away from residential development. The contiguous ownership of the surface provides opportunities to do so. And this type of reasonable collaboration with the public and gaining of social license is what I'd hope the operator would engage in when I provided direction to work with the community during the CAP hearing. Although a voluntary ALA was already submitted, Rule number 307B3 states if the Commission determines that additional information or analysis, including an alternative location analysis or an analysis of additional locations, if an alternative location analysis was already conducted, is necessary for it to make a decision to approve or deny an oil and gas development plan, it may stay consideration of the oil and gas development plan for further consideration until the director or operator can provide the Commission with the additional information or analysis necessary to consider the oil and gas development plan. The applicable statement of basis and purpose on page 79 states, the alternative location analysis is the Commission's primary and best tool to avoid adverse impacts, because the most effective way to avoid adverse impacts is through siting decisions. So I believe it's reasonable here to require further analysis. One example of supporting evidence for this is that the CPW SwiftFox protocol is more flexible than the impromptu map presented during the hearing by Crestone suggested, i.e. for SwiftFox, there is a half-mile no surface occupancy buffer from dens, but that's between March 15th and June 15th, and any construction and occupation can generally take place outside of that time period if the location is greater than a quarter mile from the den site. And it appeared from the map that alternative one is outside of that quarter mile buffer, but admittedly, given the scale of that map, it really was difficult to tell. It is very common practice that wildlife managers employ temporal timing restrictions to minimize impacts to wildlife. We do it often when developing in and around varying types of large ungulate habitat. So to me, given just that one example, it is likely, as pointed out by Starr in its closing argument, that there are other potential nuances and site options that have not yet been examined or that at least have not been adequately presented as alternatives to this commission. So to me, for these reasons, my position at this point, and again, I'm interested to hear what my fellow commissioners have to say, is that the alternative location analysis that was provided, even though it wasn't required, wasn't sufficient. I think it's been demonstrated that further earnest examination could result in opportunities to better cooperate with this community regarding its concerns of protection of public health, safety, and welfare. And as such, I believe it's reasonable and necessary to stay this application to diligently seek a workable alternative location for the Sunlight Long Pad farther from residential development at the boundary of the Lowry Ranch property, as I suggested at the CAP hearing. And we could do that by requiring that a comprehensive alternative location analysis be prepared, as allowed for in the rules that I've cited. My preference would be that we direct Crestone, in accordance with 307B3 and 302B2C, to prepare a narrative analysis that identifies all potential alternate locations from which the targeted minerals can be accessed that may be considered for siting of the oil and gas location. And specifically, my direction would be to make its best efforts to examine sites that are farther east of the proposed location. So lengthy, I apologize, but those are my thoughts as I've pondered this application.
Thank you very much, Commissioner Ackerman. Appreciate you leading us off. Commissioner Cross, you had raised your hand right after Commissioner Ackerman, so we'll go to you next, and then we'll go to Commissioner Messner.
Thank you, Mr. Chair, and thank you, Commissioner Ackerman, for leading us off. I also want to provide a little bit of introductory comments a little bit before I get into kind of the meat and potatoes of this application. I want to begin by addressing some process points from the application to this point specifically. I want to thank staff for their work on this. It's been a long, detailed process with numerous iterations, and our staff has put in a lot of good work to get this application ready to come before the commission. It goes beyond the substantive issues and review from engineering and the location analyst specialists, but also to the public involvement done from our community relations team. In addition to their day-to-day work, we had numerous members of staff, including Deputy Director Mercer, Hearings Manager Thomas at 511 hearings. We also had the lead location analysis specialist for this OGDP, Brian Christopher, attend every one of the 511 hearings on the Lowry Ranch to date. I want to ensure that this effort does not go unnoticed and make sure that staff knows how appreciative I am of their work. I also want to thank our sister agencies for their input and consultations. As additional issues arose, CPW continued to work with the applicant to ensure that we, as a commission, can know how to meet our legislative mandate to protect wildlife resources, So thank you, Brandon. Similarly, thank you to Tessa Sorensen with CDPHE for the work done with the application to push for more BMPs and to ensure that we know what is necessary to protect public health, welfare, safety, and the environment. And thank you as well to the State Land Board for continuing to answer our questions and your participation in these proceedings. Finally, I want to thank the hundreds of stakeholders that have provided their input and lived experiences to us in written and oral public comments, as well as during the 511 hearings. I do think it's important to address that some of the comments we heard during the stakeholder input. First, we are listening. Numerous times we were told we don't listen to comments, we don't take them into consideration. We do. From my individual perspective, your comments help me understand issues that I may not have thought of, as well as gaining perspective about what information may not be clear to everyone in the application. Based on that input, I craft questions to address the topics you raise, be it drinking water, seismic concerns, wildlife, or, as we'll talk about next, alternative locations. Before we get to the alternative locations, I want to start by saying the basis of my analysis is consistent with what Mr. Foote set forth in his opening. We must issue a decision using the standard set forth in ECMC Rule 301A, which is the Commission will approve operations only if they protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and protect against adverse environmental impacts on any air, water, soil, or biological resource resulting from oil and gas operations. The Commission may require any conditions of approval that are determined to be necessary and reasonable to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, or to protect against the adverse environmental impacts on any air, water, soil, or biological resource resulting from oil and gas operations. Based on this standard, I assess the application and the arguments protesting the application by looking at whether the proposed application is protective, and if not, whether COAs could make it more protective or make it necessarily protective. Of note, this does not mean that the application must be the most protective or must avoid all risks. Ultimately, we are tasked with determining whether an application meets our rules and if it is protective. As I have stated before, this is akin to cars. They're manufactured to be safer and safer, and we have laws to minimize dangers while driving. But the only way to be completely safe is to not drive. I appreciate Mr. Lyon addressing the ECMC legislative mandate, but a prohibition is not part of our legislative mandate. Senate Bill 19-181 states that the Commission is directed to regulate the development and production of natural resources of oil and gas in the state of Colorado in a manner that protects public health, safety, welfare, including the protection of the environment and wildlife resources. This mandate is why we must only approve projects that are protective and minimize adverse impacts, or include COAs that protect and minimize adverse impacts. If our mandate was simply to protect, we would be tasked only with avoiding adverse impacts. Indeed, the mitigation hierarchy requires us to avoid impacts by selecting alternative locations, practices, or methods of operations, but recognizes there are unavoidable impacts that should then be minimized and mitigated if cannot be avoided. If all risks had to be avoided, the inclusion of unavoidable risks and minimization and mitigation of adverse impacts would be superfluous. Our legislative mandate is then adhered to by setting forth a process which seeks to avoid adverse impacts and, where unavoidable, minimize or mitigate. This is evident in the 2,000-foot setback provided in our rules. Again, I think the most important place to begin my analysis is with the alternative location. At the outset, an alternative location was not required under our rules. However, we as a commission can ask for additional analysis to ensure compliance with the rules. We have authority to mandate ALAs even if the criteria are not triggered. That's Rule 304B2A2. And even if an operator did an ALA, you can request further locations be assessed under Rule 307B3. During the CAP hearing, we indicated that we would be I apologize, just
Let's pause for a second and allow Commissioner Cross. There you go.
apologies. My dog started howling and I want to make sure that I can be heard. So during the CAP hearing, we indicated that we'd be focused on site-specific locations and their potential adverse impacts. So I think an alternative location assessment was requested and is appropriate here. First note, there was additionally an additional site proposed, one for the Sunlight DSU and one for this Long DSU, but it would not work with the change in regulations done by Arapahoe County. I do want to quickly address one of the things that Commissioner Ackerman talked about in his deliberative comments, and that's wanting practices that would be acceptable to the county and the community as a whole. As he indicated, alternative location number 1 was assessed based on STAR concerns. And the location is not supposed to be, the location not done to be, is not supposed to be done to be most acceptable to a community, but consistent with our rules. Particularly when you look at the opposition to pads by STAR of pads that were far to the east of the proposed location here, and relying on studies that say there's an increased risk to public health and safety of up to 8 miles away from a pad. So while we did hear comments that I think said we wouldn't be opposed and we wouldn't have any concerns if this was just moved further to the east, I don't think that's the case. It's inconsistent with what's been argued by STAR in other circumstances. And frankly, I'm not sure that we'd find anything that would be 100% acceptable to the community as a whole, as Commissioner Ackerman said. So instead of trying to look at what's going to be most appeasable to everyone, I want to try and look at what fits within our rules and is protective. While there was some consternation demonstrated about the small number of alternative locations analyzed, i.e. one potentially viable location, I do not find that the number of locations analyzed was not inappropriate. I do want to note that was a purposeful double negative, as I do not outwardly find that only one alternative was definitively appropriate. I don't put a lot of weight on the wildlife restrictions for making alternative location number 1 unworkable. As Commissioner Ackerman noted, if that alternative was used, the operator would have to work with CPW to ensure that no wildlife was impacted and or operate outside of timing limitations. This could be done. That said, I think the proximity to wildlife does suggest that alternative location number 1 would not be more protective of wildlife. I do find that the other reasons that alternative location number 1 was not selected to be convincing. This increased distance and step out does create operational difficulties that make the development of the entire DSU difficult, if not impossible. While minerals not developed to protect public health, welfare, safety, environment, and wildlife resources does not constitute waste, as we discussed with the Maverick petition before, I do not think the proposed location is not protective. So the potential additional protection is not reasonable and necessary to protect. And I do want to point out here, and I'll talk about a little bit in more detail as well, it goes beyond just the technical feasibility of alternative location number 1 that I think is an issue. Because as we'll discuss, I think there's also a lot of issues with the proposed access routes, the ability to pipe out as well, that are going to have additional impacts that I think would be applicable to any other alternative site looked at to the east. I will say I was disappointed in the quality of the alternative location analysis initially provided. First, the map that was created after request for additional information was far more helpful in providing information to assess the haul route, the pipeline issues, as well as why additional locations to the east were not assessed. It gave us a much more holistic picture of the challenges the operator faced when evaluating siting locations. There was argument that this map should have been provided earlier, and it should have. But that it was not provided until the hearing does not negate the fact that the information was already available in the record and available to everyone, just provided in an inferior manner. I'll take a slight pause here. I'm not sure the best time to discuss the proposed reservoir questions that arose during this hearing, but I'll try to do so here. I think the testimony was clear and supported that the East Aurora Reservoir has been abandoned in favor of proposed reservoirs B and C. Indeed, documentation shows that it was abandoned in 2018. The fact that the State Land Board provided a pre-2018 document that references the East Aurora Reservoir does not mean it's still in place. Given that the State Land Board and Arapahoe County concerns and regulations, this location would never have been approved if the East Aurora Reservoir was still under consideration, as it was projected to go further south. The approval of the State Land Board and the Arapahoe County of this proposed location confirms that the East Aurora Reservoir is not under consideration and not pertinent to an alternative location analysis. But that said, I want to address the technical feasibility and cost effectiveness is not a factor to be considered in actions to minimize an adverse impacts. While technical feasibility and cost effectiveness is not a factor to be considered in actions to minimize adverse impacts, the same provision of Senate Bill 19181 still states that minimization of adverse impacts still require the assessment of the avoidance, minimization, and mitigation measures to be evaluated to the extent necessary and reasonable to protect public health, safety, welfare, the environment, and wildlife resources. Thus, mandating an alternative that is not operationally feasible and would require significantly longer haul routes and pipeline impacts is not necessary and reasonable, particularly given the proposed location is already outside the established setback, below a ridge, and utilizing almost every BMP available. As with the more helpful map not being provided until the hearing, I had some of the same concerns with the explanations provided with respect to operational challenges. The level of detail provided to us in rebuttal is what should have been available at the beginning of the hearing. While I can appreciate the technical and operational hazards faced from laterals of the proposed length with long step outs and sharp directional changes at depth, that isn't necessarily clear to the public writ large. And I do find the record clear that the torque and friction concerns and the potential impacts of increased drilling time and downhole operational concerns was made clear during the hearing. But again, this information should have been available from the outset. So I don't think the alternative location analysis is or should be required. The testimony showed that the potential options are east. You can't go north due to the regulations around the proposed reservoirs. Moving east only provides a small number of potential options given local government setbacks and wetland NSO. There are several reasons the applicant set forth why alternative location 1, or honestly anything similar in that area to the east, was not selected, including wildlife, which again I provide little credence to, but more importantly, access, pipelines, and operational feasibility. While I do not find the wildlife concerns as detrimental, it is certainly more protective to wildlife to be away from the swift fox den. However, the significant changes that would be presented with access routes, pipeline routes, and operational difficulties in drilling do suggest the proposed location is appropriate. And I think one of the key things in response to what Commissioner Ackerman said during his testimony is when we looked at the map that was provided during rebuttal, there are large areas of NSO on either side of what was discussed with ALA number 1 because of wetland NSOs. And because of those wetland NSOs, any way in and out, it's not just a matter of the operational feasibility, the ability to get to those minerals, which are already difficult at the proposed location, but you're also going to now have to go, as I think it was something like 30 plus extra miles to the south and around to get to where additional pipeline routes would be. So when you're looking at anything east of what's being proposed, you're already going to have to deal with additional truck trips into the thousands of miles. You're already going to be dealing with additional disturbance for any pipeline routes, as well as any technical and operational difficulties with the drilling and the ability to access minerals, which, as was discussed in testimony, could include increased drilling times, having to send additional equipment in, which is going to have increased emissions that are going to potentially have to go in and fish out any problems down below. So I do think that my biggest point that I want to make is it comes to the idea of conducting additional alternative location analysis from this point forward is, given the map that we saw where there is NSO because of wetlands, not something that the State Land Board might be willing to move around and say, hey, what about this? But the fact that you'd have to go around 2 areas of wetlands, the biggest issue to me is that the pipelines and the access routes are going to have to be diverted to the south and east before going north and add dozens of miles to anything that's going to be done, which is going to have additional environmental impacts to the entire area. So next, I'm going to move on to non-ALA issues with the OGDP. First, I'll say Mr. Kloster address his testimony. I appreciate his findings, and I think it demonstrates that additional work and research needs to be done to best identify emissions, including severity of releases. Ultimately, however, Mr. Kloster testified that he had no suggestions that there was existing rule violations. He just was hoping for more information being done. With Mr. Thornton, I feel the same way about Mr. Thornton that I did during the CAP testimony. I do find him to be credible, but I do not believe his testimony demonstrates that any ECMC rules would be violated by the proposed BMPs and associated management plan, or that the proposed plan, including proposed noise management plan, would result in noise impacts that are not protective to public health, safety, welfare, environment, and wildlife resources, or do not necessarily minimize impacts. I believe the greater than 3,000 foot distance, and in many instances more than 5,000 feet from RBUs, will minimize noise impacts. However, nothing shows that the projected noise levels, as minimized by the associated BMPs, do not minimize adverse impacts to public health, safety, welfare, environment, and wildlife resources. As Mr. Thornton testified, he's not a public health expert, so he can't speak to public health or safety impacts. Instead, he notes that the anticipated noise based on Urban's ambient noise study, which he said are believable, credible, and realistic, are audible. From there, he states that audible noise will be reduced by increasing the distance of the pad from people. Ultimately, Mr. Thornton had three conclusions. One, he wants more data in the study, but didn't say that the applicant is not compliant with the rules. Two, physics shows an increased distance will result in decreased noise and therefore be more protective. I agree, but again, it doesn't say that the project does not meet rules and more protective is not the standard. And three, using lower noise equipment will result in lower noise levels from the project. Again, agreed, but not arguing that the applicant is not complying with the rules. And in fact, the applicant agreed to CDPHE BMPs to minimize noise impacts. As with Mr. Thornton's testimony during the CAP, his concerns are more pointed towards the scope of and impact of our rules, as opposed to the proposed project. While I acknowledge those concerns, this hearing is not an assessment of those rules, and my focus will be on compliance with the rules we presently have, which are met. Ultimately, my decision comes down to whether the proposed application is protective. With the BMPs committed to by the applicant, I believe it is protective and appropriately minimizes adverse impacts. This is not to say that it is as protective as it possibly could be, because more could always be done, including no drilling at all. But that is not our mandate. Again, for the stakeholders that have addressed this possibility, not drilling is a possibility, but only if adverse impacts cannot be avoided, minimized, or mitigated, which is not the case here. Before going into our setback, I think it's important to note that the EnviroScreen score here is approximately 14 under the EnviroScreen 1.0, and approximately 17 in EnviroScreen 2.0. That is one of the lowest we've seen in the entire DJ basin, including locations that are more than a mile from the nearest RBU. I think that one of the most important decision points for me is that the proposed location is more than 3,000 feet from the nearest RBU. This is significantly farther than the 2,000 foot setback in ECMC rules, which was determined in rulemaking based on public health studies and agreed to by our public health agency, to be a distance which potential adverse impacts greatly decreases and is thus protective. To argue that this distance does not properly avoid adverse impacts calls into question every other application we have evaluated and approved to date under our new rules, or to somehow say that the impacts at this location would be different than other locations. But there is no evidence to suggest that that is the case. I agree that all potential health impacts are not eliminated at 2,000 feet, but that doesn't mean that projects at that distance are not protective. As Mr. Foote stated in his closing, moving the pad farther away from RBUs increases protection, but suggesting that the established setbacks are not sufficient is a problem to address in legislation or rulemaking, not an individual application. Indeed, changing course from our established setback in this application begs the question: at what point is the line drawn in the stand? Star witnesses and public comments suggested we look to recent studies which provide association of cancer rates with proximity to oil and gas sites. Setting aside concerns with the limitations of these studies, as Mr. Lyon testified, these studies suggest impacts up to 3 miles and even up to 8 miles away. So avoidance alone is not the only tool in our tool belt. and to suggest that requiring sites be more than 3 or even more than 8 miles away from RBUs is inconsistent with our rules and renders other protections that we have superfluous. Additionally, I think it's important to note that as I talked about all the other applications that we've approved that are closer than 3,000 feet, many of those have been done after these studies that have been cited to have been published. So it really does try to say no here, tries to say there is something different about this location. And really the only thing we've seen different about this location is the amount of public opposition to it. I do want to say, additionally, STAR has suggested that the location simply be moved. And as discussed before, they also opposed other locations as being too close. And even alternative location 1 would still have potential adverse impacts consistent with the studies that STAR cites. 2 final points. First, I want to quickly address some of the fire impacts that were raised in public comments and in testimony. This danger is unlikely, as the site will have remote shutting capabilities. And I think it's important to note, as we saw on the West Slope this last summer, where there were wildfires, the pad construction, including berms and removed vegetation, as well as remote shutting capabilities, actually served as more of a buffer from the wildfires than something that's going to spur additional fire concerns. I want to finish by saying, rather than subject this application to a make it even safer regardless of what our rules permit approach, I look to the overall application proposals. Here, the applicant has agreed to nearly every single BMP CDPH he suggested to be incorporated to protect public health and air and water resources. The applicant has moved the access road to address concerns. It's taken on additional wildlife BMPs, agreed to electrification of the drilling rig, and 3-tier pipeline takeaway. Simply put, the BMPs agreed upon here and the operational plan are some of the most protective measures we've seen. But trying to say this is not protective merely because a great number of people are opposed to it is inconsistent with what our legislative mandate is and what our rules require.
I'm trying to unmute. Thank you, Commissioner Cross. Commissioner Messner, you'd raise your hand next.
Thank you, Chair Robbins. So appreciate the opportunity to share my thoughts, and I think you'll find that my thoughts mirror in most ways with Commissioner Ackerman's and his approach. And so I appreciate Commissioner Ackerman providing the information that he provided in the rules that he stated and the quotations from the statement of basis and purpose. And so for some level of brevity, I'm not going to repeat many of those, but do agree with his citations and his rationale. But to me, there's no doubt that this application has created some of the most attention of any application that I have had before me since I've been on the commission. And I do want to make sure that it is known that I have heard and internalized all of the different perspectives that have been provided throughout this process. This process was designed to be transparent, inclusive, and provides numerous tools for affected parties to be involved and provide perspective, helping shape and evolve applications and have influence on decision-making. And the parties to this proceeding have utilized all of the tools that have been provided to them, have invested time, money, and emotional capital into providing their thoughts and perspectives, and importantly, have provided thoughts on potential solutions rather than just identifying potential problems. This is unique to me, as many of the controversial proceedings that I have been involved with have parties that primarily identify problems without identifying potential solutions. So I do applaud all of the parties involved for taking this next and important step in engaging with this commission. Here's the basic summary of some of the potential solutions I have heard from different parties during this proceeding. I'll start with the applicant. Civitas has been working diligently on this application for a significant amount of time. They have made a number of adjustments to the proposed location based on feedback from a number of different stakeholders. They had to work with the State Land Board and its constrictions on siting, Arapahoe County with their updated oil and gas regulations and the associated siting requirements, the City of Aurora and its siting recommendations associated with the access road and pipeline routes, Colorado Parks and Wildlife with its recommendations on timing stipulations and avoiding impacts to sensitive species and habitats, with local neighbors to minimize and mitigate potential impacts associated with operations, and with ECMC to try and meet the requirements of the state regulatory agency. They have employed an impressive array of best management practices, including grid electrification of their drilling and production operations, three-phase pipeline takeaway for oil, gas, and produced water, a tankless facility design, continuous air quality monitoring, employment of leak detection and repair technology, Tier 4 engines during completion activities, freshwater transport for freshwater use during operations to eliminate truck traffic, 32-foot full wrap sound walls, no permanent lighting, and a full cadre of stormwater management tools, wildlife timing stipulations, and emergency management and wildfire protections. These efforts should be applauded for attempting to find solutions to adverse impact. I think Maverick has also identified solutions to a potential problem of stranding minerals that could constitute waste. They have suggested modifying wellbores or approaches to the DSUs that would enable Crestone to recover the minerals they are targeting while still draining the minerals that Maverick would like to see drained. And finally, STAR has provided solutions to potential problems as well. STAR has been attempted to be characterized as an activist organization, and while it is clear that there has been some influence on the group from statewide and national organizations, I know that it was created by a group of concerned citizens who are located in the neighborhoods within the vicinity of the proposed operations as a way to be cooperatively engaged in the public processes that are available to them and to provide the perspectives necessary to evolve applications before the commission, as they should be. I appreciate their participation. And while there were many differing perspectives from neighbors and even members of STAR, from the testimony, evidence, and statements provided by STAR as a petitioner, I did not gather that STAR's proposed solution was to stop oil and gas development, but rather to move this proposed location as far as reasonably possible from the neighborhoods in which they live. So here we have three different parties, one applicant and two petitioners, coming to the table with not only concerns and problems, but with potential solutions to the problems. Now, I realize that they have different proposed solutions to the potential problems, but again, I applaud them. In this hyper-partisan and divided nation in which we find ourselves, this is unique. But I am always impressed with Coloradans, as finding workable solutions to challenging problems is very much the Colorado way. So I see this as an opportunity and not a roadblock. Now, to the facts of the case, the hearing on this particular OGDP was preceded by a hearing and ultimate approval of the Lowry Ranch Comprehensive Area Plan. And while I voted against the ultimate approval of the Lowry Ranch cap, primarily because I did not feel that the potential cumulative impacts associated with the proposed developments were adequately evaluated and addressed within the application materials, I did indicate that I felt it was certainly possible that some of the individual OGDP locations proposed within the cap could be approvable. And in fact, I have voted to approve those individual OGDPs that have come before me since the cap was approved. This commission as a whole during the cap hearing identified that the State Sunlight Long location could be the most challenging location within the cap once it came to the individual OGDP hearing. And in fact, it has been. Comprehensive area plans are designed to be just that, comprehensive planning processes in order to look holistically at the potential adverse impacts associated with proposed development and to look at solutions for evaluating and addressing cumulative impacts associated with proposed development. Understanding this, the commission directed the applicant to pursue and implement electrification of all operations and OGDPs within the cap, which the applicant did. And it also directed the applicant to evaluate locations for the state sunlight long location that would be as far away from the neighborhoods as reasonably possible, which I do not believe that the applicant has adequately done. STAR has provided significant evidence and testimony on the record regarding its concerns with the potential adverse impacts associated with the proximity of this development to their neighborhood. The applicant has provided a suite of best management practices to attempt to minimize and mitigate these potential adverse impacts. But in these efforts, the applicant missed the directive given to it by the Commission during the CAP hearing to evaluate and analyze alternative locations that would place the location as far away as reasonably possible from the neighborhood that is expressing the concerns regarding the potential adverse impact. This was not done in the self-titled voluntary alternative location analysis, nor was it evaluated and addressed in the cumulative impacts plan. Alternative location analyses by rule are required to only provide locations for evaluation that are technically feasible as per 304-2C ICC. The applicant provided no locations that were technically or regulatory feasible except for the proposed location. The last-minute response to Commissioner questions regarding Alternative 1 in their voluntary alternative location analysis was appreciated, but not helpful in the sense that it rationalized why a chosen technically infeasible location would not work, but did not fully explore in depth alternatives that were technically feasible, that were regulatory feasible, that may have timing stipulations or need for waivers, but could be possible, could use back sails, sail ends, 2 pads versus 1 pad, or reconfiguration of the DSUs, etc. This would provide me with the necessary information, assuming I had enough time to fully analyze and I digest it, for me to be able to make a decision. It is not this commission's job or responsibility or burden to analyze alternatives on behalf of the applicant. It is not this commission's responsibility to determine whether other alternatives are available. It's this commission's responsibility to evaluate technically feasible alternative location analysis that are provided to us by our request. The burden of proof does lie with the applicant. I believe STAR as a petitioner has provided ample credible evidence in the record as to why it feels like it should be concerned. They have provided published and peer-reviewed studies that are specific to Colorado as well as other states. They have provided expert witnesses to provide perspective on those studies. And while the applicant has provided witnesses to attempt to discredit the studies, I believe that the fact that these studies are duly published and peer-reviewed and have applicability to Colorado provides credibility. I remind folks that this is a petitioned application, which brings evidence into the record formally that is required to be reviewed, considered, and weighed, which is different than an application that does not have a petitioner. In those situations where there is not a petitioner and there's no additional evidence being brought into the record, then we weigh the application on its merits based on the rules. As there's additional evidence being brought into the record in a petitioned application, there's additional evidence that has to be evaluated and weighed in addition to the applicability to our rules. As with the CAP application, I also have concerns that the cumulative impacts plan associated with this application does not meet the requirements associated with Rule 304C19 to fully evaluate and address the cumulative impacts of oil and gas development in the surrounding area. What was provided was superficial and missed the mark. There is ample information in the rules, the statement of basis and purpose, and guidance documents regarding the elements necessary to meet the requirements of this rule. I have cited these in CAP hearings as well as previous hearings with this operator. There are many who would like to reduce the rules to a check-the-box exercise, but they are not that. They are a performance-based regulatory system which requires the applicant to clearly make a showing on how they will evaluate and address both direct and cumulative impacts. It allows for the feedback and involvement of many stakeholders and parties. It requires the utilization of judgment based on data and evidence in the record. In the end, the application of the mitigation hierarchy, which is the backbone upon which our rules are based, requires avoidance as the first and primary way to address adverse impacts. Even in situations where we have dueling testimony regarding public health, there has been common ground found in the fact that distance generally is the best tool available for addressing adverse impacts. Based on these circumstances, the evidence in the record, and the fact that the commission directed the applicant to analyze locations further away from the neighborhood that has the significant amount of concerns, I think it is reasonable and necessary to require the applicant to perform a full alternative location analysis for locations as far as reasonably possible from the dense subdivision with concerns. I cannot evaluate locations that I do not have information on, and that information was directed to be given at the conclusion of the CAP hearing. So as to the Maverick portion of the hearing, I do not believe that the applicant, who holds the burden of proof, has shown that they cannot provide access to Maverick's minerals due to constraints associated with the protection of public health, welfare, the environment, or wildlife resources. I believe Maverick has shown that there may not be technically or regulatorily feasible locations from which it could access its own minerals. So stranding these minerals, as well as other minerals that are associated with the CAP, could be constituted as a waste per the Act. So where I'm at is the following. I would ultimately like to see a motion that would require the applicant to conduct a full, formal, and robust alternative location analysis for sites that are as far as reasonably possible from the concerned subdivisions. These sites should be technically and regulatorily feasible and be able to access the minerals targeted, including the potential for looking at Mavericks minerals and other stranded minerals associated with this comprehensive area plan. The applicant should engage with the State Land Board regarding updates to the tier map. It is more than reasonable, based on evidence in the record, to think that due to the fact that the East Aurora Reservoir is no longer being pursued and Rangeview has confirmed the settled boundaries of Reservoir B, that the Tier 1 no surface occupancy area that was previously identified on State Land Board maps due to the boundaries of the East Aurora Reservoir would be contracted to better align with the settled boundaries of Reservoir B. This should provide more opportunities for pad siting and access and pipeline infrastructure. They should consult with CPW for concurrence on potential wildlife concerns and evaluate potential options for pipeline and access road siting. They should consult with Arapahoe County for the potential for siting exceptions. They should explore all available technology. The applicant should also evaluate the potential need for 2 pads if necessary. While it is almost always encouraged to utilize the least number of pads possible, the design and layout of the proposed DSUs may or may not allow for the utilization of 1 pad. So I would like to see all technically and regulatory feasible options presented and analyzed. I request all of this information under Rules 307B3 and 304B2A2, which allows for the Commission to request any additional information in our analysis, including an alternative location analysis, to ensure an application is protective of public health, safety, welfare, the environment, and wildlife resources. I would also like to request an updated cumulative impacts plan that robustly evaluates and addresses the potential cumulative impacts as per Rule 304C19, the SBP, and guidance provided by staff on this topic, including the required qualitative and quantitative elements taking into consideration the recently approved OGDPs associated with the Lowry Ranch CAP applications and other adjacent to the CAP boundary. So I would recommend that we stay this application until this has been provided to the Commission for review. I do want to reiterate that I appreciate all of the work and perspectives provided by each of the parties in this hearing and the fact that they came to the table with not only problems, but potential solutions. I believe this approach will provide an opportunity for these potential solutions to perhaps be combined to come to a result that works for all. Thank you, Mr. Chair. Those are my deliberative thoughts.
Thank you, Commissioner Messner. Commissioner Oath?
Thanks, Mr. Chair, and thank you to all of my fellow commissioners. I think given the thoroughness of all of your comments, I can really mostly cut to the chase here, specifically around my thoughts on an ALA, and I have maybe a side comment about the reservoirs. But before I get to that, I guess I wanted to make one additional comment. A number of commissioners have made some comments about the portion of the testimony related to the public health studies that occurred during this hearing, and want to also say that I certainly agree that the health risks of oil and gas development is certainly of critical interest, certainly for me as well, in reviewing these applications and in doing our work. In this case, and in this record, there were the various studies discussed, and we had experts on the respective sides reaching opposite conclusions regarding, what the key takeaways are, and specifically whether our current regulatory setback and other requirements are sufficient to protect against health risks given these studies. And I think what I would say is, our efforts to investigate these studies and fully understand them and consider whether any changes should be considered in response are really incredibly important and timely. And to me, I think it was demonstrated through the cross-examination and the questioning done with the experts here on both sides that these issues and these studies are nuanced and very complex, and they certainly warrant investigation and consideration. So, I want to call out and raise attention to the fact that we have a process that we have embarked on to consider what the implications of these studies are on our work. And so, we've convened a panel of experts who are able to consider the complexities and help us as a commission more fully understand what the key takeaways are from the studies, both individually and as a body of research that continues to develop. I don't feel that I can make a conclusion in this hearing based on the adversarial nature of these proceedings that, the current regulatory requirements are insufficient, for example. But I think it's important that we continue to investigate and consider all of these studies. And I believe that the process that we have underway is the appropriate way to do that. So turning back to kind of the bottom line for me on this is, whether Crestone has met the burden to demonstrate that they've complied with the act and the regulations when proposing this location. And to me, notably, that means have they demonstrated that they have fully considered the mitigation hierarchy, and specifically to demonstrate that the proposed location avoids and minimizes impacts to public health, safety, welfare, the environment. I will also say I appreciate that Crestone brought forward some additional information during this hearing in response to commissioner questions to provide more information and analysis about alternative one. But honestly, it felt very rushed, and there really was not an ability for our staff to review it and consider it prior to making a recommendation, nor were the consulting agencies had the ability to review and consider this additional information prior to providing their consultation memos. As has been noted, Crestone was aware of and on notice that the commission would be looking for a thorough analysis of alternative locations given the discussion during the CAP hearings, but Crestone did not do so in advance. And as has been pointed out by previous commissioners, our rules do allow for the commission to require an ALA to be done or for additional locations to be considered. And I agree that that is necessary here. So I also am and would be in favor of staying the matter until additional locations that may have less implications to public health, safety, welfare, and the environment have been analyzed. And then with respect to reservoirs, I came to a somewhat different of a place than Commissioner Cross. for me, the record is not entirely clear that the East Aurora Reservoir has been abandoned, and really, I appreciate the documents that were pointed out by Crestone that indicates that. And then on the flip side, we have a state land board letter referring to the East Aurora Reservoir as a potential future reservoir, and that was the basis for designating the area as Tier 1 NSO. And that was, raised just at the start. That was in the letter that was submitted by the state land board at the beginning of this hearing. And so we're sort of left with conflicting documents, with the more recent one suggesting potentially that it is, still a potential future reservoir, but then with an implication that because Aurora Water, Rangeview, and the State Land Board didn't object to the proposed location, that therefore that means that the East Aurora Reservoir has been abandoned, and that may be so, but to me, I consider the record to be unclear for me on this matter. So if in my thinking, I would like to see this matter stayed for purposes of more thorough location analysis to be done. But I would also instruct Crestone during that time to provide some verified information on the record to clarify that the East Aurora Reservoir is not a potential future reservoir. Thanks.
Thank you, Commissioner Oath, and thank you to my other commissioners for the deliberative thoughts. First, I want to note to everyone that's listening in, we've kind of got the largest crowd ever, 297 folks. I did not attend in person the 511 hearing, but I did, the 511 hearing was videotaped, and I listened to the 511 hearing, so I just want to make sure everybody is aware of that. Some of my stuff is duplicative, but in reviewing this, I note that pretty much all of the agencies that had consult were in approval of the Sunlight Long Pad. The city of Arapahoe had a lengthy approval process and they approved it. CPW did a lengthy consultation and they do not have any concerns. CDPHE, in their comments, noted that every applicable BMP is being used and there are no more we would advise that are needed. The Aurora Water Department, whose entity is and mission is to protect the Aurora Reservoir, says the proposal does not impact the Aurora Reservoir. The State Land Board, in an 8-page letter that we read into the record, created detailed, extensive work to get to a protective oil and gas lease. Multiple years of getting to that. Aurora and Arapahoe were involved. There were stipulations with regard to stewardship. They created a tier map. They approved the SUA. They are the landowner. In May of 2024, they were okay with the location. They asked for and got the relocation of the access road away from the reservoir because of the work with Aurora and Arapahoe. As noted by Commissioner Cross, the EnviroScreen score is 14.7. Most permits with approvals have scores in the upwards of 40s and 50s and 60s. This is I would note, and I went and did my research on this, this is the lowest score for a proposed permit in Weld, Arapahoe, and Adams County. So it's the lowest score for wells located in and near people. There was a requirement by the commission to electrify all phases. This is unique and certainly minimizes impacts. 3-phase takeaway, as noted by some of my commissioners, all pipes, no trucks, remove and reduce tanker trucks. Our setbacks are met. There's no DICs, there's no RBUs, there's no schools. Arapahoe County approved the noise mitigation plan. Again, the access route was approved by the State Land Board in Aurora. Visually, the only time this location is going to be seen is the top part of the derrick when it's being drilled. Afterward, it is not viewable by any of the residents in the neighborhood near 3,188 feet away. Again, it did not trigger any ALA. There was a voluntary ALA. I'll get to that in a second. But I conclude, well, I also want to note that STAR who I appreciated their involvement in this and appreciated the petition and appreciated listening from folks. But neither Star's attorney nor the folks that generally testified on behalf of Star, they did not cite a violation of any of our 146 protective rules. The violation that they sought is the 147th rule, which is the meet the rules and also be protective of health, safety, welfare, and the act. I find that to be deficient. And I find that this location is one of the more approvable locations that we've looked at. And I would, if we got to a vote to approve this, I would be in favor of approving this location. SB 19181 was not an oil and gas ban. Governor Polis said that. Senate President Finberg said that. House Majority Leader Casey Becker said that. It was a measure that raised protection of public health equal to development of oil and gas resources. Having said all that, I hear my fellow commissioners and a majority are interested in directing for an additional ALA assessment. I would agree with Commissioner Ackerman that of all the locations that we've looked at, this one is certainly subject to the potential for different locations. It's a thousands of acre ranch with no homes and buildings on it. I would agree with Commissioner Ackerman that we direct Crestone to create a narrative to look at alternative locations where the targeted minerals are assessed. I would agree with Commissioner Meshner that there should be engagement with the State Land Board on revisiting the tiers and revisiting with Arapahoe County potential variances to some of their setbacks. I don't have a problem looking at multiple wells if that's going to be safer. I also would like the analysis to include locations in which there may not be an ability to target all the minerals. And I'd like an assessment of the non-targeted minerals, the non-developed minerals. And I'd like that assessment to also include an analysis of how much safer that might be. And this gets to the definition of waste and the fact that at times waste is not non-development of the resources if it's necessary for protection of public health, safety, welfare, the environment, and wildlife resources. So those are my deliberative thoughts. Commissioner Ackerman, do you desire to make a motion?
I desire, I'm not sure if I'm able. I think perhaps AAG Boudreau has been taking notes, I would hope, and maybe he can help me out.
Thank you, Commissioner Ackerman, Mr. Chair. So based on my notes, I think I have two different aspects here. One, as between Crestone and Star, it seems as though we have 4 commissioners in favor of a stay. And if in my view, if the application is stayed, that means that you don't necessarily need to make a motion on the case as between Crestone and Maverick at this time. The whole case would be stayed. But seeing as how Crestone, as between Crestone and Maverick, it appears that we have 3 commissioners in favor of essentially denying Maverick's petition. So putting all that together, my recommendation would be a motion to stay the application with instructions to the applicant as indicated in the commission's deliberations. No decision on the DSU application or petition from Maverick at this time, as the entire application would be stayed, but that the commission could indicate they've essentially made a decision on the DSU and won't address that at a future hearing, and that there's no final agency action at this time as the entire matter is stayed. That's pretty long-winded, but I think that captures everything.
And I don't think I have any questions unless other commissioners do, but I'm amenable to making that motion and also.
Second. Did you make the motion?
You did.
Okay.
So you seconded the motion. So we have a motion and a second. Is there further discussion on the motion? Commissioner Messner?
Thanks, Mr. Chair. I think there was a number of things that were asked by different commissioners to be included in an alternative location analysis associated with this. And so I don't think all of those things need to be included with the motion, but I do think that it would be important for the applicant to address all of the things that were identified by each of the commissioners.
Hey, agree. I also think and AG Boudreau, help me if you can here. I almost would like you to parse through the deliberative thoughts and put together a document that illustrates the various assignments on the ALA, and then make sure that the applicant has that, so that they don't miss anything by not catching it. And I don't know if that's appropriate or not. We've never done that before, but it seems like to me that roadmap would be helpful.
I think that's acceptable. So without adjustment to the motion made by Commissioner Ackerman and seconded by Commissioner Messner, I can go through the deliberations, come up with basically a list of topics that the commissioners would like addressed in Crestone's additional ALAs, and then I can communicate that to Crestone's council.
Very good. Thank you for that. Further thoughts on the motion? Hearings Manager Thomas, let's do a roll call.
Commissioner Ackerman,
Yes.
Commissioner Cross,
No.
Commissioner Messner,
Yes.
Commissioner Oath,
Yes.
Commissioner Robbins.
Yes.
Mr. Chair, the motion passes 4-1.
Thank you. All right, to the 304 people that are still out there listening to us, we thank you for your dedication and for participating with us in this hearing. I think we've got a path forward for the commissioners and for the applicant to develop additional information so that when we get to a final determination on this, we feel we're in the best place for making the correct determination for the state of Colorado. With that, I move to adjourn.
Second.
All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Thanks, folks.